SJC-12209, Commonwealth v. Walter Shelley. Mr. Sheketov, good morning.
Good morning, Your Honor. Please, the court, Robert Sheketov for Mr. Shelley. This is an unusual circumstance. It's generated where a lesser included offense has a statute of limitations that is significantly different than the greater offense. That happens with murder because it has no statute of limitations, and manslaughter, which does. It also happens, or at least it used to, on some sexual assaults, like the Bugas case, where indecent A and B has a different, significantly different statute of limitations than rape. And of course, the legislature is free to resolve this problem by just changing the statute of limitations. But as it exists now, we have a conflict in cases like this between the constitutional right to present a defense, in this case the statute of limitations, and the constitutional right to have a fair trial, which in this case means a lesser included offense instruction on a set of facts that clearly would permit a jury to find the lesser included offense. And there is no question in this case that that set of facts existed because the Commonwealth raised the issue with the court pre-trial, saying that there was a Supreme Court case called Spaziano that had decided this case squarely and held that if you want to persist in your statute of limitations defense, you couldn't do it. You'd have to waive it because it would be a trick to deceive the jury into thinking that they were convicting you of a crime that didn't exist.
Sheketov, was Mr. Ferreira tried before your client?
Yes.
Okay, and he's found not guilty.
Correct.
So why isn't it perfectly reasonable for your client to make, after careful consideration with trial counsel and a serious and lengthy discussion with the judge to make a decision that he doesn't want to waive it, and he knows he's not going to get the manslaughter instruction. He knows what the result was in the Ferreira case, and that's the consequences of a strategic decision.
Well, he didn't make that strategic. Well, you're correct, Your Honor, that in the circumstances that he was in, where the judge had announced that it's one or the other, he made a strategic decision. Right. But he persisted in his view that he was not required to make that strategic decision, that he was entitled to have this conflict of his two constitutional rights resolved the same way we resolve all other conflicts, like, for instance, when you have a Fifth Amendment right to remain silent, but you have a Fourth Amendment right to try and suppress something. We make some accommodation where you don't forfeit one right in order to assert the other.
What do you think, what's your position about, I wasn't clear, about the Vermont approach?
So I think there's a better approach than the Vermont approach, which is to just say you're entitled to both.
But with an instruction that you got to know that the statute is run on the lesser.
Why?
And I mean, so, that's what Vermont says.
No, that's exactly what Vermont says. But I'm looking for something better than Vermont, because why tell the jury that? We don't tell the jury, for instance, when you're deciding this case, a confession may have been suppressed, but don't consider that fact.
In the Vermont case, as Justice Bartlett, I think, is pointing out, you're basically telling the jury, find him not guilty. If you find him guilty of manslaughter, it's a not guilty.
Correct. You're telling the jury what the consequence of their fact-finding is. And thinking about...
I should let you answer what you were going to answer, what you think the better solution is.
To not tell them anything about it. because their job is to find the facts. And I was thinking about what would be a better compromise than Vermont, and I thought of this idea that we use in federal court in RICO cases, where you would give a subtle suggestion to the jury that there might be a difference here, because you would ask them guilty or not guilty of first-degree murder, guilty or not guilty of second-degree murder, and on manslaughter, you'd ask them proven or not proven. So you would be telling them, in effect, that there's some kind of difference here, and not quote-unquote tricking them, but you wouldn't be telling them that the consequence of their verdict is to let the guy walk, because they are not to be concerned with the consequence of their verdict. Many times,
But all right, but hypothetically or theoretically, why is the reasoning, just on that point, why is the reasoning of Spaziano so incorrect? That is, yeah, what you say makes sense, except that that crime isn't available anymore. So the only crime available is murder.
right, but the reason the crime is not available is because we have a statute, because you have a
These are
constitutional right.
statutory crimes.
Right, the legislature could change the statute if they wanted to, but that's why I suggest proven or not proven, because then you're leading the jury to think there's some sort of distinction here, but you're not spelling out what that distinction is.
The jury asks, what do you mean proven, not proven? What is the judge supposed to answer?
That it's not your concern what the consequences of your verdict is. Your concern is to find the facts without sympathy or prejudice as fairly as you possibly can.
Now, the minority of states other than Vermont, Mr. Sheketoff, do they just have a lesser included and the consequences are whatever they are, and the person, if they don't find a statute of limitations, is acquitted?
That's my understanding, Your Honor. We trick the jury in numerous ways in reality, not in this circumstance. I don't even see it as a significant trick. We suppress confessions.
Yeah, but this is different from keeping evidence from the jury. This is indicating that a jury which returns a verdict believing that they have convicted the defendant of a crime is in fact going to learn that they have effectively found him not guilty, even though they intended to find him guilty of something.
Well,
I don't know of any other time in which we do that.
I think, respectfully, Your Honor, we do much worse than that. We suppress confessions.
But we suppress them on the theory that they are, there's a voluntariness question. I mean, you know.
But there's also a Miranda warning question. We suppress confessions because Miranda warnings weren't given.
It goes to the same point, doesn't it?
Well-
There's a question about, at the end of the day, there's a question about voluntariness?
These are separate inquiries. With the Miranda violation, it's not really a voluntariness
Isn't
question.
your argument as simple as this? I hear what you're saying. Propensity evidence, excluded all the time. OUI fifth offense, the jury doesn't know about the 4 priors. They don't know anything about, presumably, about the breathalyzer. And you're saying, like, I think Wisconsin, and I can't remember the other state, maybe New Jersey, that takes the position that you're taking, that it's really no different than that.
Right, that is my position, and especially where what you're asking the jury to do is find facts, not to consider consequences. If I sat on a jury and found out that a confession was suppressed, I'd feel much more deceived, or if it was the 6th OUI, than I would if it turns out there's a statute of limitations defense that the defendant had the right to assert. That means that even though I found that, in fact, this was a manslaughter, I mean, the judge might have given probation in those circumstances. I have no concern about what the consequences are as a juror. And we can certainly say proven or not proven if we have to make some effort to assuage the feelings of people after they find the facts, which is their sole job.
Well, it's not just the feelings of the 12 jurors. I mean, we can't ignore the pink elephant in the room. I mean, this was a 15-year-old boy who was, killed, horribly killed, and it was a tragic situation, and if the jury is going to come back with manslaughter, the question is whether or not they should know the implications. It may well be that all the government can prove beyond a reasonable doubt is a manslaughter. I'm not sure what the problem with the Vermont system is.
Well, I prefer the Vermont system to ours, but we usually don't tell juries what the consequences of their verdicts are. I mean,
We do in criminal responsibility.
yes, and we do in that circumstance. I would like it in more circumstances. I would like it when my client is charged with statutory rape. I'd like the jury to know that there's a possible life sentence. I would like it when my client is charged with trafficking. I'd like the jury to know if they find there are 200 grams, he's getting 12 and a half years. That's irrelevant to their decision-making. And in fact, if the appropriate decision on these facts is manslaughter, the way to change the consequence of that is to get the legislature to say there's no longer a statute of limitations on manslaughter. Why does the Commonwealth benefit from the fact that the defendant has a complete and uncontested defense to the charge of manslaughter?
And what happens if there was a dispute of fact as to whether the statute of limitations had run, either because perhaps he was out of state for some period of time? What happens then in your world?
Well, in the world as it presently exists, if this trial judge was right, the Commonwealth says to the court, we don't intend to even try and prove that the statute of limitations is run, because even if we had 100% or 99% chance of proving that, we're abandoning that. We're not going to present any evidence of that whatsoever, because now the defendant has to waive it. He has to waive it. Why should we have a litigation risk?
Well, why should he waive it if there's a dispute about whether it's run or not?
Well, because he'll be faced with this choice. On the record, he'll be told, you either waive your statute of limitations defense or you don't get an instruction on manslaughter. So the Commonwealth, having not contested when they could have, but without 100% certainty, the issue of the statute of limitations, now puts the defendant in the position where he has to abandon the statute of limitations completely. He can't, because it's to their advantage. He has to waive it in order to get his manslaughter instruction, which, the parties aren't supposed to determine what instruction the judge gives based on the evidence that's in front of the jury. So that's the problem, I think. Why contest it if you're the Commonwealth? You have no reason to contest it because you're going to force the defendant to waive it if he wants his manslaughter instruction. I can't think of any other circumstance where we take these two rights that a defendant has and we just say you have to abandon one of them.
But if we had the Vermont rule, the jury would then be asked to go on and determine whether or not the statute of limitations had run.
If there was a contest, and there would be grounds to, well, yes, the jury would have to
I mean,
decide.
you put the Commonwealth in the peculiar position of trying to prove the statute of limitations had not run. For a lesser included, it will tell the jury it should not find.
Correct. But here, the Commonwealth acknowledged right from the beginning that this was a reasonable verdict in the circumstances. I think the trial judge acknowledged that too. I mean, the difference between a high likelihood of substantial harm, which is the third, what we used to call the third prong of malice, and which is manslaughter, and a plain and strong likelihood of death. This is a difference with, that only lawyers could think of as making a difference. And
Mr. Sheketoff, does it matter how the statute of limitations came to run in the case? Does that factor into it at all in the circumstances of this case? I guess it was.
Well, it's just time. They had a witness who, a co-venturer, according to him, who this bothered over the years and eventually came forward under a certain amount of pressure and told his story. The first jury for the defendant, who was the actual principal, didn't believe that witness and acquitted.
Well, I mean, what would it be any different if the defendant had left the jurisdiction and
Yes.
you would have a different rule?
Well, then the Commonwealth would have had a possibility of disproving a statute of limitations defense. But in the system that we're in now, if the trial judge was correct, the Commonwealth would have no incentive to try and prove that, because
So you want us to craft a rule that takes into account a case where the statute of limitations is litigated, it's close, and where the person, your client, absolutely deserves a manslaughter instruction?
correct.
Okay, thank you.
Time's up.
Ms. Kirschenbaum, good morning.
Good morning. May it please the court. Laura Kirschenbaum, Assistant District Attorney for Middlesex, on behalf of the Commonwealth. First, I'd just like to address what my brother said about this being a conflict between two constitutional rights. The statute of limitations does not present any constitutional rights.
I think he said it was a constitutional right.
He said it was a conflict between the constitutional right to present a defense, and I'd suggest that that's different from the statute of limitations, which is an affirmative defense that can be waived, but does not present any sort of constitutional right along with it.
Isn't there a due process right to a lesser included instruction?
There is a right to lesser included instruction, but I don't think that necessarily conflicts with the statute of limitations right. And the judge here—
Why not?
Because it's a statute. It's the defendant isn't constitutionally entitled to it, and all that the statute of limitations requires is that an indictment be found and filed within the limitations period. And here, the Commonwealth didn't indict on the lesser included because they couldn't from the statute of limitations, but it doesn't necessarily bar the defendant from being convicted as a lesser included outside the limitations period, at least not by the plain language of the statute. And under the guidance of Spaziano and the majority of jurisdictions, the judge here correctly gave the defendant the choice between asserting the statute of limitations defense and having the jury instructed on the lesser included. And
What do you say to the I think the rationale of why of Spaziano and other cases is if the jury would feel terrible about not having a conviction, but if the jury but the other side of that is if the jury's just given a murder and there really is a very good manslaughter set of facts, and so they know he's guilty of something, and it's an all-or-nothing proposition, so they're going to pick the murder, even though, in truth, fairness would say, this is really a manslaughter. What are we supposed to do about that? Is that fair?
I think that is fair if the defendant opts to go for the all-or-nothing route between murder and acquittal.
No,
And I think
It's not much of a choice, though, is it?
No.
it's absolutely a choice because the jury are instructed to determine whether the facts of the case that they find to be true meet the elements of the prosecutable offenses, which are murder.
There are cases where, for instance, a defense attorney has an "I didn't do it" defense, and they also have a self-defense. They would have a self-defense instruction, and a defense attorney may say, "Judge, don't instruct on self-defense because my position is I didn't do it, and you're gonna instruct me out of my case." And that's a choice, a reasonable choice a defense attorney can make. That's a real choice. But here, there really isn't a real choice, is there?
I disagree. There is absolutely a choice. If the jury don't find that the Commonwealth has proven murder, then they're instructed to acquit, and that's what they did in Mr. Ferreira's case. And the defendant here was aware of that outcome, and that's why he made the strategic decision to go all or nothing between murder and acquittal. And it's important to note here, the jury found first-degree murder, although that was subsequently reduced by the trial judge. They were instructed on second-degree and first-degree, and they found first-degree. So we also are outside the realm of Beck, where there was no third option for the jury to find. Here, the jury declined to find the lesser included that they were instructed on.
Now, let's imagine that this case was prosecuted 5 years after the events. You go to trial, and for whatever reason, the defense lawyer does not seek a manslaughter instruction. Would that case stand?
If there's an issue of ineffectiveness for not pursuing the lesser included, I think that would have to be litigated separately, but that sort of case has arisen many times. I don't see the statute of limitations really having an effect on that.
It wouldn't, because of course it's within 5 years.
Right.
So the point is, if there's no statute of limitations, and if the judge were to say, if the judge in this case were to say, I'm not going to give a manslaughter instruction, I assume that would be error.
If the instruction were requested by either the Commonwealth or the defense and the judge declined to give it, yes, that would absolutely be error.
So under Woodward.
Yes.
So now and what if there's ambiguity as to whether or not the statute of limitations has run, either because there's ambiguity as to the timing of the killing or ambiguity as to whether the defendant has been out of state for some period of time?
I believe where there's a dispute, a factual dispute as to whether the statute of limitations has run, that's something that the jury needs to decide. And in that situation, they would be instructed on the lesser included, along with being charged with deciding whether the statute of limitations had run.
So tell me what that instruction would say to the jury.
I think it would say you are instructed to find that this crime occurred within the statute of limitations period, and part of that is deciding whether the defendant was in state or out of state or whatever the complication is. And they'd also be instructed on the elements of the offense. But
And
where there's...
would it also tell them that if you were to find that the statute of limitations has run, the consequence of that finding, based on a finding of manslaughter, would be that the person would be found not guilty?
I think you would have to instruct them on that, because we instruct them on the elements of any offense. If you don't find that any of these elements are met, you are instructed to find the defendant not guilty. So I don't think you would give them any sort of different instruction here. Even if you did, they would probably assume that they're deciding the statute of limitations for a reason. But where there's no dispute as to the statute of limitations, and it's clear here that the statute of limitations had run, there was no factual finding for the jury to make. And there was no reason to instruct them on manslaughter if the defendant refuses to waive the statute of limitations.
Let me suggest this imperfect solution to you, very imperfect solution to you. What if the defendant decides not to waive the statute of limitations? And it's a case where a manslaughter, it's palpable that there's really a good chance of a manslaughter. And the defendant's in a difficult position because they want to go all or nothing. What if the judge had the authority, with the consent of the defendant who had been convicted of first a second-degree murder, you could argue whether it should just be limited to second degree, to have a hearing where a 26B2 reduction to manslaughter would be possible?
Unless the defendant waives the statute of limitations at the 25B2 stage, I don't think the judge could consider manslaughter.
Sure, of course. No, but of course they're going to.
Well, in this case, no, the defendant...
No, I'm not explaining it well. Trial's over. Defendant decides not to stipulate as to the statute of limitations, not to waive it. Jury comes back on what very well might be a manslaughter, walks, talks, looks like a manslaughter, and they come back. They're not going to acquit if they think that the defendant killed the person. They come back second degree. And then the judge has the option, with the defendant's consent, which he or she would undoubtedly give, to consider a reduction to manslaughter.
I think if the defendant pursues the strategy of not presenting the lesser included to the jury, I don't think it should be before the judge on a 25B2. But the judge does have the authority to order a new trial if the judge feels that the facts of the case don't add up to murder, if the judge feels that maybe this was more of a
Judge
manslaughter.
can reduce it, doesn't have to just order a new trial. Judge can reduce it under 25B2.
Can reduce it to an offense, a lesser included offense, but where there was no lesser included offense, the judge can't reduce it. The judge can't enter an acquittal where the evidence was sufficient to prove the prosecutable offense. So here, where there was sufficient evidence of murder on second degree and first degree, the judge under 25B2 can't enter what effectively would be a dismissal.
Can we get back to the position you take that if the jury didn't find murder, they just acquit, so there's no prejudice to the defendant? Isn't that counter to all of our law on lesser included offenses? Can we say that about every lesser included offense?
The difference here is the defendant is free to argue to the jury, hey, look, if you find that I did something here, it was manslaughter. And you can argue to the jury forcefully, this was only a substantial likelihood of harm. You separate it from the substantial likelihood of death. And you can put that before the jury and assert your statute of limitations, and the jury's well aware of that distinction. And the jury know if they find that this was only a substantial likelihood of harm, then they have to acquit. And I think that that's fair here, where there was no lesser offense for the jury to find. I certainly think the jury shouldn't be instructed on manslaughter and be given the opportunity to find manslaughter only to have the case dismissed. I think that deceives the jury and undermines the justice system. I also don't think we need to instruct them that they should acquit if they find the statute of limitations.
So they wouldn't have the benefit of an instruction, say, for excessive force in self-defense?
I'm sorry?
So if, under that theory, they wouldn't have the benefit of an instruction on greater force in self-defense, for instance?
Well, if there were evidence of any mitigating factors.
Would that be before the jury, or is it be up for the defense attorney to argue that?
Anything that would reduce it below murder, I think, would be up to the defense attorney to argue to the jury.
Without the benefit of an instruction?
But the judge won't instruct on that?
But there's no reason to instruct on it because it's not an offense that the jury could find the defendant guilty of. And the purpose of the jury is to deliberate on whether the defendant is guilty or innocent of prosecutable offenses. These aren't crimes that the Commonwealth could indict for. It's not, if we had tried to indict for manslaughter, the defendant would have won at a motion to dismiss early on in the stage. So there's just...
Is it a miscarriage of justice if the defendant is convicted of the crime he's actually guilty of? Which sounds like what could have happened in this case.
If he's...
How is that a miscarriage of justice? If he's convicted of the crime that he's actually...
Meaning manslaughter?
Yes.
Well, if all he did was manslaughter, and the jury found that all he did was something less short of murder, then he would have been acquitted, which is exactly what happened to Mr. Ferreira.
Well, the jury didn't have a chance to consider that in this case.
But to instruct them on a crime for which they can't find the defendant guilty, we run the risk that they see in the news that the defendant was acquitted of the crime that they just deliberated over and poured over the facts and found him guilty of.
So why do we put the jury's feelings over the defendant's interest in justice? I don't understand that.
Because we want jurors to have trust. We want everyone to have trust in the judicial system and the way that our jury system works. We trust juries to follow the instructions and to find the elements of the offense or else to acquit. And I think that happens.
Well, one last question. Does it make any sense to think of the statute of limitations as a restraint on the Commonwealth rather than a restraint on what rights the defendant can assert?
It's a restraint on the Commonwealth in terms of limiting the extent to which we can prosecute certain offenses. But I don't think the statute of limitations benefits the defendant so much here, where the larger crime doesn't have a statute of limitations. I mean, the point is so that individuals don't have to worry about being prosecuted for offenses way down the road when memories have faded and facts are obscured by the passage of time, but where there's a greater offense.
Involving the same lack of memory.
Involving the same memories, but there is no statute of limitations. The statute of limitations really doesn't have any effect for the defendant.
Can you help me out? I'm having some trouble understanding this. I'd like to return to the discussion about if there was ambiguity as to whether or not the statute of limitations had run. Did you, is it your position that the jury then has to find the facts on that as well as get manslaughter instructions?
I think that would be appropriate.
So doesn't that put a defendant in a better position if there's ambiguity than as to whether or not there's certainty as to whether or not the statute of limitations? It's an odd thing.
It is, but it would also,
I mean, and what would happen if the jury said, okay, the statute of limitations has run, but we've gotten instructions and manslaughter is the right crime, so we're going to find him guilty of that?
so if they find the statute of limitations had run and that the facts are more consonant with manslaughter, then they would follow the instructions and they would acquit. But for it to be a truly odd situation, you'd have to have a defendant raising the statute of limitations defense and then hoping that the Commonwealth is going to defeat his defense that he's raising instead of just accepting it. I mean, when else do you have a defendant trying to defeat his own defense?
Well, I know, but that's the only way you're going to get the manslaughter instruction.
And because there's no constitutional right to the
Okay,
statute
we're
of
going round in
limitations.
circles now, aren't we?
Unfortunately, that's a problem with the situation where there's no real answer. But I'd also just like to point out that the Vermont instruction was necessary because at that point the statute of limitations wasn't waivable in Vermont. Subsequently, Vermont, the legislature changed it to make it a waivable thing. But here in Massachusetts, because the statute of limitations is waivable, this court should follow Spaziano and the majority of jurisdictions that find that the best option is for the defendant to be given the choice, as he was here, between asserting the statute of limitations defense and having the jury instructed on lesser included.
All right, thank you.
Thank you.